Very good. All right. Could the associate please read the appropriate form of words?
Thank you, Sir Jeremy. Good morning. This directions hearing is in the matter of case number CFI 005-2016, CFI 009-2023, before Justice Sir Jeremy Cooke, appearing from the United Kingdom. Any orders or directions made will be issued on the judge's instructions by the registry in Dubai. The claimants are represented by HFW. Lead counsel is Mr. Sharif Sheef GKC. The defendants are represented by Jones Day. Lead counsel is Ms. Heather Martin. Thank you.
Yes. Mr. Shifty.
Good morning, Your Lordship. Thank you for seeing us at short notice this morning. There are a number of case management issues that we thought it would be useful to bring before Your Lordship. They really arise from two things. One, the defendant's, in inverted commas, counterclaim, and the second is their applications to strike out the entire proceedings. If I may, I'm going to try and take the categories together. I know that we've set this out in some detail in our skeleton, so I won't rehearse that, and hopefully we can move swiftly to the nub of the issue. The first point I wanted to start on was their, in inverted commas, counterclaim. This is an application that they say is brought under Article 102 of the insolvency law, and in a nutshell, it seeks removal of the liquidator, alleging his misconduct. And amongst other things, it's alleged that the liquidator is committing an ongoing tort in accepting funding in pursuit of this litigation. And in that Article 102 application, the fourth defendant seeks to hold him personally liable for significant sums. Notwithstanding all of that, it's the fourth defendant's position that the determination of the issues in that matter should be deferred until the whole matter, as in my client's claims, go to trial, which on any current estimate is some time away.
Your Honor, I can shortcut that. That's not our position.
Right. Well, it's obvious to me that it's a matter that has to be sorted out first. I mean, it goes to his authority to act, and it's pointless to have anything else decided whilst that issue remains open. So that's got to be decided, and indeed, it might affect the whole question of proceeding altogether. So the only question now is putting that into the right setting, so to speak, and making sure that we have an appropriate timetable that works for the parties. All right, so can we park that and put that to one side for the moment, because looking at the rest of the issues, dealing with the points that are agreed, and also how one focuses on the other strikeout.
I'm grateful. But before we leave that point, my lord, can I? There are a few other aspects of it that I would like just to have on your lordship's desk. One is the point about the process. Now, this isn't some sterile debate between insolvency lawyers as to what the correct procedural route is. There's a more fundamental point, which is actually what is the most sensible way of getting this application forward. And I mean, obviously, it needs to start with evidence, because we need to know what the evidence is against the liquidator and then have a chance to respond to it. That is also the correct procedure under Part 54. Part 54 isn't permissive or optional. It is mandatory for insolvency proceedings. But in any event, even if your lordship thought it was optional, it is the option to choose on this matter, because ultimately we need to know what the case is against us. We shouldn't have a round of pleadings. That will just delay matters. We need to see the material relied on to sustain these serious allegations and have a chance to respond to them. We can move very quickly, and for obvious reasons, we think we ought to, because really for the reasons your lordship articulated, we can't have this hanging over us. We need to know the answers. The estate needs to know the answers, as do creditors, as a body. And so we think we really ought, on our side, we really ought to shift in order to get it on quickly. The ball lies actually in Miss Martin's court, in that she needs to file her evidence. We say they should do that in the maximum of 7 days, and then we will respond within 14 days. Effectively, it should proceed under the ordinary timetable for ordinary applications. So that would be 7, 14, 7, and then that would bring it on for hearing. We think probably in the second full week of March is what we're looking at. And we think that that's probably the realistic timetable. I mean, we just looking at logistics on our side, it would be difficult to squeeze it to get it much earlier than that. And I myself am in a trial in the UK in that intervening period, so it causes me personal difficulties. So that's what we're looking at, but obviously subject to your lordship.
Yes. May I be heard on these points, Your Honour?
Yes, you may. Of course, you may. I was going to ask you in any event. The first thing I need to know is whether you have in fact filed all the evidence you wish to file in the form of Devonish 7 and the points of counterclaim with the statement of truth, or do you wish to file any more evidence?
Devonish 7, unless I am misstating what we filed, relates to the strikeout application and not to the counterclaims. Correct.
On its face, it does. Yes.
Yes. And so no, we have not filed the evidence we wish to file. We wish to have disclosure. We think it's very important in these circumstances. Just to give the court an example of why disclosure is needed, for instance, on the solicitor's conflicts, which we brought to the attention of Mr. Berganza and his team. His immediate reaction was to tell him not to talk to him about it, to go talk to HFW's legal risk department about it. We wrote to them about it. They immediately wrote back with sort of a blanket denial and no further information. And we wrote to them with a lot of questions because we wanted to come to the court with a fully informed pleading, whether it be in the form of an application or whether it be in the form of counterclaims. That had as much information as possible about whether or not HFW advised the liquidator of this potential conflict of interest, whether or not there was any scope of advice that was carved out from their ability to advise him, and if so, what the liquidator did about the fact that he might not be being fully advised as to potential claims against Mr. Walia. We don't know the answers to any of those questions. Those are the subject of disclosure, and it would be incredibly prejudicial to us if this were to proceed as an application in the absence of disclosure.
Well, I don't quite see that you're entitled to disclosure of privileged material, but there we are. I mean, on the face of it, the view that I take, so you know, is that there is a procedure that's set out in the rules that ought to be followed, and that doesn't, on its face, allow for disclosure. Of course, if you seek disclosure and no disclosure is given, then there may be inferences to be drawn. One understands that, but the broad picture must be that you should produce your evidence. The liquidator should produce his evidence, and then you can produce evidence in reply. And I wasn't thinking of doing anything beyond that. So far as Holman's position is concerned, HFW's position, I understand it to be, and this is only from, I think, reading correspondence, that they did act for Mr. Walia's lot, if I can put it in those terms, but ceased to act in 2017. I think that is broadly the position. How that impacts on the issue, of course, is another question. But do you need to know anything more in any event than when they cease to act?
Yes, Your Honor. For instance, the engagement letter itself is not privileged. That is a position that the claimants have taken in this proceeding, and so I'm sure they won't backtrack on that here. We would expect that the engagement letter would set forth the scope of the representation, and if there are any limitations in it, that they would be denoted there. Obviously, we are looking for disclosure of the ATE policy. We are looking for the disclosure of the litigation funding agreement. We are looking for disclosure of the correspondence with the Al-Kharafis on that matter. There's a lot of...
Those are all points that you can make, that you can put down your list, and I would have thought that to the extent that there's an unwillingness to disclose or to be open and frank with the court, then you can rely on inferences.
Okay.
But it seems to me that one ought to observe the procedure that is set out in the rules, and we proceed on that basis. This is quite an unusual application. as I'm sure you appreciate. I don't suppose you've done it too often yourself.
I haven't done it too often myself. There is some precedent for it, or we wouldn't have done it.
Yes. No, of course it can be done. And if there's if the liquidator is proceeding when he shouldn't, then the court will say so.
Thank you, Your Honor. Could I just ask that we don't have any real objection to this proceeding as an application.
No. I understand. You've done it wrong, but let's put it right. Yeah.
I do think that there is at least one matter in there that if we are to frame this as an application, that it's really just going to boomerang back on us and we're going to lose rights. And allow me to explain that if I could. The allegation of inducement of the breach of the settlement agreement, it doesn't truly arise under Article 102. If the court can allow me a minute to find the reference to the portion of the law of obligations, we did cite it in our pleadings, but in any event, it arises independently. And the reason that this comes up for me is having read the cases cited by the claimants in their skeleton. All of them, I think, if not at least almost all of them, arise in the context of a dispute about the standing of an applicant or a claimant to bring a particular application under the insolvency statute. And so what those cases say is that even though there's sort of a broad gateway that allows multiple classes of people to bring insolvency applications, for instance, if one is to bring one as a creditor, one has to be representing the class of creditors in order to credibly bring it. Now, there is an argument to be had that all of the creditors have an interest in having a liquidator who isn't inducing breach of a settlement agreement. But I think that the relief related to that is really quite conceptual, whereas in our case, we're applying under the law of obligations or have a pleading that cites the law of obligations as its basis for relief that is very direct in that we are the party directly harmed by that inducement of breach. Now, it could be any party that induces that breach. It doesn't have to be a liquidator, but in this case, it happens to be a liquidator, and we are deprived of the $9.5 million that our client, the fourth defendant, has paid to have that settlement agreement put in place, which is now rendered essentially useless because it's not doing the thing it's meant to prevent happening.
Well, I understand that. That's a slightly separate point, isn't it? I mean, so far as removal of the liquidator is concerned, if you're relying on that as a ground for his removal, it obviously comes within Section 102. To the extent to which you wish to pursue that, should you, as a claim against the liquidator personally, query whether or not that's properly within the proceedings or not, or whether it's actually a separate claim altogether, because it's against the liquidator, it's not against the company.
Okay.
So it seems to me that one's got to separate out the issues. The one I'm most concerned with at present is your reliance on it as a ground for removal of the liquidator. I understand there may be a separate cause of action which could be pursued differently. But my immediate reaction, and I haven't thought this through, is that if it is a separate cause of action, it probably doesn't find a place within this litigation in any event. It would have to be done elsewhere, so to speak, differently against the liquidator.
Okay.
I don't know. I haven't thought this through, but you see the point.
We spend a lot of time with the rules trying to figure out how to bring this forward. And our reading of the way that the RDC is drafted is that counterclaims is very broad. And so we brought it under a reading of the rules that just considers that to be broad. Now, there is also this provision for other claims, which the RDC says should also be heard with semi-related matters. Maybe it's one of those, but I think even if we had entitled the other claims, it just would have need to be accompanied by a different form and still brought at the same time, maybe not in the same document. I'm not sure that gets us to any different place where we have a situation where different heads of claims might according to the court need to have been brought in different ways. We're happy to bring it however the court prefers, or we note that under Rule 4.51, the court has the power to remedy it itself.
Yes, I understand all of that. The question is, what's the most efficient way? As I say, the first question is to deal with the liquidator's position, and to the extent that you rely on this as a ground for removal of the liquidator, that he himself is tortiously acting or has acted and I don't know whether you say continues to act to induce a breach by Carafi of the settlement agreement. Obviously, that's got to be dealt with within the context of the removal application. And in one sense, I think a lot of the other stuff can wait until we see how the removal application works out, because we then see what there is that's left in one way or the other. So I'm conscious of your point, and it doesn't seem to me that necessarily a strikeout of the counterclaim is appropriate. It's probably got to be rethought if this proceeding continues after the application for removal of the liquidator, which, to say in my view, plainly has to come first.
Okay.
So I think the real issue is simply one of setting an immediate timetable for that that makes sense, bearing in mind the other elements that may or may not need to take place thereafter. But broadly speaking, subject to the agreed directions, which we can go through in a minute, the position ought to be deal with the liquidator's position first. If the liquidator is removed, well, that's a new liquidator will have to be appointed, and then everything will have to be rethought so far as this litigation is concerned. If he's not removed, then the next thing must be to deal with your strikeout application. And I think it makes sense to provide for that at this stage, not knowing what the outcome will be of the removal of the liquidator, simply in order to avoid undue delay with people's diaries and so on, setting dates and all the rest of it. So my inclination would be, subject to what the parties submit, to set a timetable for both of those things, one following after the other. Does that make sense, Ms. Martin?
I believe it does make sense. I would just add one more request in this regard, and that is to the extent that we are made to submit evidence with this application, which we are happy to do, that likewise, because the claimant's insolvency application falls under the insolvency statute, that they also be made to submit evidence with theirs, which they never did. All they appended was the consolidated particulars of claim. We just want the parties to be held to the same standards.
Well, I don't think there's much in that point, which is really why I was asking you whether you wanted to rely on any extra evidence. And the position so far as the claimant is concerned is they did file an affidavit for Mr. Hyder, and he referred to the particulars of claim, and there's a statement of truth in the particulars of claim from Mr. Hyder, so that we have evidence for that purpose. But at all events, on this particular application, there will be an opportunity for you to produce whatever extra evidence you want, and then Mr. Shivji to produce his in response, and you get a reply if you need it. So the question is one of timing. Now, what's realistic so far as timing is concerned? You've heard what Mr. Shivji has suggested, which involves a hearing, he thinks, sometime in March. We're going to have to look at diaries to see just how practicable all of this is. I haven't examined mine with any view to this particular hearing as yet. Let me just look. And how long do you think you need, Ms. Martin, to produce whatever you need to produce?
Can we say 14 days for now with leave to produce any additional evidence if it becomes necessary?
Well, we'll set you a limit. I mean, it'll be done simply according to RDC 54 or whatever it is, the one that deals with applications. So, you get time to produce your evidence, and then Mr. Shivji produces his, and you can produce some in reply if you want. Now, if we save 2 weeks for that, that will take us to where are we today? We're the 25th today. That would be the 9th of February, wouldn't it? And Mr. Shivji, how long do you think you need? I mean, you know the guts of what's being said.
Yep.
You may not have all the evidence in support, but you know what the accusations are. Can I just make two points en passant, which a slight diversion, but raise the question of privilege. I'm very unhappy, Miss Martin, I'm bound to say, with some of your pleading.
Okay.
Where you keep saying, advice was taken on this, that, and the other, and without waiver of privilege. But the bottom line is very simple. If you want to rely on the fact that advice was taken, I think you have to disclose what that advice was. If you don't want to disclose that advice, okay, that's fine, but you can't rely on the fact that advice was taken, because relying on the fact that advice was taken inherently involves the implication that the advice said we could go ahead.
Well, may I ask, Your Honor, we did reveal the contents of the advice to the extent it was separately revealed to the auditors, to the extent that that advice was
what I had in mind, I mean, advice as to the prospects of success on the COAFI appeal. You said what that advice was. Well, all right, you may have to actually disclose the documents, but that you've waived that, and that's the transaction you've waived. But in relation, in particular, to the question of insolvency, I mean, I do find that extremely odd. I'm bound to say that if I had been looking at it and faced with a judgment for whatever it is, 65 odd million, I would know that if I didn't succeed on the appeal, the company was bust by a distance. You know, joint and several liability only applied to the first 30 odd million, and the second 30 million, the punitives, were only payable by the company. So you'd know you were bust. And what's hinted at, and I'm not sure it's said expressly, is that they were advised that it was fine and there was no risk of insolvency. Now, all I'm saying is, and I haven't analysed your pleading in depth, is that you're going to have to make a decision as to what advice you do wish to rely on and what you don't. But what you can't do is say we were advised and then not say what the advice was and reveal it. So come the time, whenever that may be, you'll have to look at that.
We very much thank the courts for its heads up.
The second point, of course, arises in relation to the whole position of Holman, Fenwick and Willen. HFW, do they still call themselves Holman, Fenwick and Willen, or are they simply HFW now? I always think of them as Holmans from my past. But anyway, whoever they are in the Middle East, HFW Middle East, the question arises as to what should and should not properly be disclosed in the context of their representation of clients. Now, the dates when they ceased to act and began to act seem to me to be plainly, appropriately, a matter for the court. But advice about conflicts, I would have thought was on the face of it privileged, and therefore it'd be a question for Mr. Shivji once again whether he wishes, or whether his client wishes, I should say, to waive privilege in relation to that or not. I have another question in that context, and it's just so that you can be thinking about this. Supposing the position was that I thought that Holman's had been in a position of conflict, one might have thought the answer to that issue would be that HFW shouldn't act, rather than that the liquidation should be removed. Now, again, I haven't thought that through, but it's a matter for everybody to think about.
But I'm grateful.
The point, hold on, Mr. Shivji, the point being rather obviously that if the suggestion is that HFW have a conflict and can't advise objectively, then that's not grounds for removal of the liquidator. The liquidator ought to have independent advice in which that conflict doesn't arise, and he can decide whether he ought to be suing Mr. Whalier and everybody else along with the people he is currently suing, which is one of your complaints, of course. Anyway, there it is. I throw that out without making any directions, just so the parties can think the position through, and if necessary, you'll have to make submissions on it if there's an issue that I need to resolve. Anyway, having said all that, which was a diversion, back to the timetabling point. If Miss Martin has two weeks, 14 days, what do you want, Mr. Shivji?
Perhaps if I, without being impertinent, can ask your lordship where you think this hearing might end up. I mean, as I said, we will squeeze the timetable to get it done quicker if it can get the application on quicker. If it doesn't make any difference, then I might take a week or
Yeah,
so
well-
longer. I mean, I basically what I said to you is we could do it in 14 days, which remains the case. That is obviously going at a pace. I would
Yeah.
rather have 21 days, but I'm very happy to do it in 14 if that means it brings it on in a hearing in March.
Right, well, let's look. Presumably, Miss Martin, basically you'd get 7 days for any response evidence. That would be the norm. So well, supposing we did that, that would be 9th Feb, 23rd Feb or 1st March, depending on whether it's 2014 or 21. 7 days then takes you to, yeah, okay.
So my lord, we had in mind that you could bring it on, subject to your lordship's view, at the end of the week of the 11th, or if not, in the week of the 18th.
Well, I can't do the week of the 18th because I've got a arbitration all week. I need to read a little bit before that. How long do we think this hearing on removal of the liquidator will last? Best guess.
So our estimate is 1 day, and as I understand it from my learned friend's skeleton argument, they seem to say 1 day as well, because they say that if it's amalgamated with the strikeout, which obviously it won't be, then the whole thing would be 3 days, and they say the strikeout would have been 2 days. So they seem to say this adds an extra day. That is also our estimate. 1 day would be sufficient, we think.
We believe 1 day is sufficient.
I'm always suspicious about these time estimates. I can do something in that week of the 11th. I would rather earlier in the week simply because of the hearing I've got the following week.
Of course.
So probably ideally Tuesday the 12th would be the best date, assuming the court can do that. But if we're going to do it virtually, there shouldn't be a problem. How does Tuesday the 12th sound?
It's perfect for us, my lord, and I'm very grateful for that. And but my if I may, my preference would be to do it virtually, simply because otherwise it's a logistical issue for me to get to the DIFC.
Yeah, no, but I'm the same, and it's not, unless someone wants to call oral evidence and cross-examine the liquidator or anything of that kind, and that would not be the norm, but it's obviously if it was applied for, I'd have to consider it. But absent the need for oral evidence, perfectly well dealt with virtually. And Tuesday, the 12th of March, therefore, would seem to fit the bill. So on that basis, we'd be talking about 9th Feb for Miss Martin, then do you want to take 17 days or something?
Yes, that's exactly what I was going to suggest. That would work perfectly. So that would take us to about that would take us maybe to the 26th then. And then Miss Martin could have to the 4th of March.
Yeah. And
then skeletons due on close of business on the 8th of March with that, or would your lordship be content with first thing in the morning on the 11th, or is that too late?
As long as I have them by first thing London time on the 11th, I'm happy. If we said by skeletons by 9 a.m. 11th, well, whatever 9 f, that's 1 p.m. isn't it? 1 p.m.
Yeah. Why don't we say midday DIFC time, and then
very good. Yeah.
And then that gives a little bit of flexibility.
Yes, then I can read them over breakfast. Yes, thank you.
Beautiful. So I'm very grateful. That works well for us. Thank you.
Your Honor, we're content with this timetable. I would just note that it will be our intention to ask for some limited disclosure. We will get that request out as early as possible, but I just want to make sure that the court is prepared to deal with that serially, I guess, with this timetable.
Yes, as I say, I don't, on the face of it, see that as being part of the procedure that's envisaged. That's not to say it's impossible, because nothing is impossible in a sense under the court rules if it's thought appropriate. The ordinary way in which I think applications of this kind would proceed would be for you to ask for material, and to the extent it isn't produced, you can ask the court to draw whatever inferences you think are appropriate. If you feel they're hiding things, not being candid, whatever it is. I'm sorry, Mr. Shivji, I've just now lost track of the date that we agreed on for skeletons.
So that was the
Monday
so
morning.
Yeah, Monday. I think we said midday DIFC time.
Yeah.
Which would get it to your lordship's desk on time. So Miss Martin's evidence on the 9th of Feb. That's her evidence in support of the application. My evidence in answer by the close of business on the 26th of Feb. Miss Martin's evidence in reply by close of business on the 4th of March. And then skeletons, as we just said.
Yeah, and the hearing on the 12th of March, a day being set aside.
I'm grateful.
Okay.
So as not to be accused of failing to adhere to formalities, does the court want us to issue a separate application notice in respect of this hearing?
Will that involve additional cost, Miss Martin?
Yes.
My lord, can I just say on this? I obviously I'm not looking for them to incur more court fees, although I'm not looking to deprive the court of its fees. It seemed to us that the counterclaim just is not sustainable as a matter of procedure, and if they withdraw that and say to the court that they should be given credit for the fee for that for any application, of course we would be encouraging of that. But also, as I understand it, the fee for an application is a nominal amount. But the reason why, I mean, it's a matter for the court whether it wants its fee. What I want, though, is an application which makes it very clear about the relief that they're seeking and the legal basis for it. And I say that, and I do want to just address you for a moment about the contents of the application, and we'll do that once we've dealt with procedure. But it does matter to my client to understand the legal basis for the application, and as a result, that then has consequences in terms of what the court's powers are to make an order. And your lordship, I'm sure, will be looking to guidance from us to say to your lordship, this is, if they're right about this issue, these are then the options. And that, I mean, as insolvency lawyers, that's part of our job, and as the office holder, that's part of our job. So I just think the premise of it is important. And once we finish this particular discussion, well, actually, can I just explain just very slightly why this goes back to your discussion about the contents of the application. If I just take you to their pleading, it's quite easy to illustrate what the concern is.
Yeah.
If we go to their pleading, which is A tab 9, and this is paragraph, we'll start with page 193, paragraph 171.
Yeah.
So they explain there 171 that they're bringing these counterclaims under Article 102. That is everything. If you go back to 170, page 192, that then explains essentially the limbs, the 6 elements of this counterclaim, and they're all to do with the liquidator's conduct. And the final point is this point about inducing breach of contract. And just for the record, we say that in the removal application, they must rely on everything that they want to advance. We can't have this piecemeal world where complaints emerge later. If they've raised points, they should be on the table here. We think the inducement point, whether the liquidator is acting in breach of a contract, is an element which the court has the power to deal with under Article 102, and it ought to be dealt with because we need clarity. If there is some problem with us discharging our role as we currently are, we would like to know. We can't have a world where it's said, oh, you're committing a continuing tort, but we'll just leave that hanging over you for months or years. And sorry, Manuel.
I would just note that this is
sorry, Miss Martin.
Let's have one at a time.
Let me just finish my submissions because
don't worry, Miss Martin, you'll get your chance.
Thank you.
So, my lord, and just in terms of the breadth of the court's jurisdiction under Article 102, it is very wide. So 102.1 provides that any.
I'm just looking, trying to find it. Is it in your list of authorities? The Act.
Sorry, I've got it up separately. Let me just check whether it's in the bundle. Yeah, sorry.
Here we are. I think I've got
You
it.
got it. Yeah, and if your lordship has a look at 102,
Yeah.
it's a very broad range you've had. There's 102.1 and 102.2.
Could we have the page number, please, in the bundle?
It's in section. I've got it under K2. Looking at the court bundle. You got that, Miss Martin?
I believe it's 986 of the consolidated bundle.
Yeah, it could be. It is. You're right.
So, so my lord, we'll just look at 102.1 and 102.2.
Any question?
Yeah, any question arising in the 102. So it's a pretty broad jurisdiction, and we're for our part, our position is that the inducing breach of contract allegation ought to be addressed in that forum because it affects the future conduct of the liquidation. I mean, the liquidator can't be in this world where it's said he's personally liable for discharging his what we say are his statutory duties. So we're not going to take a point that it's outside. In fact, our position is it's inside, and Miss Martin's position is it's also inside because that is the premise on which she's brought her counterclaim. So
yeah.
So
well, I've got that point. Let's say it's relied on as part of the reasoning for his removal. The point I was making earlier was that if there's to be a personal claim against him, query where that's best heard and dealt with.
Yes, well,
let's deal with this point first. Removal.
Yes,
but my understanding, Miss Martin, and you can correct me if I'm wrong, but basically your claim against him is you want him removed from these, and that's the fundamental point that I've got to deal with in the context of this application. There may be ancillary points about liability and so on and so forth, but that's the primary position.
I don't know that we consider any of them primary, Your Honor. We consider them all serious. We think his failure to obtain insurance cover or take advantage of the insurance coverage is problematic. It certainly affects all creditors. And we do consider his continuing inducement of the Al-Kharafis. If he is continuing to take funds from them, again, this is a question we don't know the answer to, but we assume that that's the case. There's nothing in his statutory duties that requires him to take money from the Al-Kharafis. He said he went out and shopped for litigation funding. He can take funding from somebody else. This is a separate head of claim that, although it does also feed into the removal application, has its own prayer for relief. And this is, and I'm sorry to have interrupted, but I thought that we had come to a conclusion on this point, and then I thought Mr. Shiji took us around to sort of a circular place where he's saying, no, this all needs to be decided in the same place, and we don't want to end up in a position where we're stopped or considered to have committed an abusive process for bringing these separate heads of claims.
No, but I'm just laying down a marker that if they don't pursue these points on the Article 102 and they drop it or say it's for later, then there will be a consequence for them. Because our concern, just putting it bluntly, I'm afraid, is that these are tactical steps designed to worry the liquidator personally in order to affect the way that he discharges his statutory function. And out of that concern, we say that the liquidator does need clarity from the court, and they want a ruling on whether this conduct is inducing breach of contract, and we want a ruling on that too. We would want the court to determine that point because it does. It would be. I mean, it's the sort of thing that if someone else wasn't making an application, we would be saying, well, this is a really unacceptable point to have kicking about. So it is. We don't think it's a good point, but it is a point that needs to be resolved once and for all. We think it's a bad point. We think it's a short point, and it can be dealt with. If we're right, then actually that is the end of the road in terms of a claim for inducing breach of contract. If we're wrong, then of course there may be all kinds of consequences, and I accept that.
Well, there are two or three points that may arise out of that. The first, of course, is what the settlement agreement says, and I've seen now it being quoted, and you're content, Miss Martin, that it should be disclosed if I make an order for its disclosure.
Yes, Your Honour.
So that will solve that, and one can then look at it and see what it actually says. But the second question is, and this is what troubles me a little more, is if there are questions of fact, findings of fact that are necessary to decide whether or not there has, quote, been an inducement, unquote, of breach or whether it's simply sufficient to show that the Carafes are acting in breach. So, you know, there are three different points. One, what's the contract say? Two, is there a breach by the Carafes? And three, has there been a breach induced by the liquidator? If I'm going to determine the point finally, that involves issues of fact.
No, I understand. So I understand your your lordship's actually right to break it down in that way. And I think I was probably amalgamating all all of those components in terms of the outcome. I think we're particularly interested in. We haven't seen this agreement thus far. Default has refused to give it to us. So I hesitate to say much about it until I've actually seen it, until my client's never seen it. But I think our sense is, in light of what they've said, that the construction, it would be helpful to know the court's view on the construction issue. So you're right that a breach of the agreement doesn't necessarily mean the liquidator is liable for inducing a breach of contract. But if there was a breach, we would like to know that, because obviously the liquidator properly discharging his functions would need to reflect on what the appropriate course is for liquidation in that context. And that my only point was really, we don't want the default to duck that point. And so it's not for now, it's for later, because that's the sort of thing we need to know. But your lordship's right, that doesn't mean that all elements of a possible claim for inducing breach of contract need to be decided finally and conclusively, because there are some components which are fact sensitive, which would need a trial. So I accept that.
All right. Can I just raise another point, which is this? To what extent do any other creditors need to be involved in all this? On the face of it, an application for removal of the liquidator would be something that ordinarily, a creditors committee might consider, and all sorts of things. A Section 102 application is bought by. Can be bought by a shareholder or a creditor, or indeed a debtor. So it seems to me that notice of this ought to be given in some way, so that anybody else who wants to join in can. I don't like the idea of opening it up to the world, but I can't quite see how one can avoid that.
So I think your lordship's right that I mean, as we said, this is about the court's supervisory jurisdiction in the liquidation. Creditors ought to know about it, and whether they're entitled. We would need to consider whether, if they were interested in making an appearance, that there might have to be then some examination of what they were going to say and whether they had enough of an interest to actually to avoid it becoming a sort of open season.
Yes.
But I think your lordship's right. I mean, can I take some instructions on that? But I'll say, my solicitors are listening, that my provisional view is that there probably does need to be some notice to creditors to say this application is issued, and to give the date at which it's being heard in public, and then it probably is in the hands of those creditors as to whether they want to do anything or not. So I'll take some instructions on that. Can I just mention one other point? I'm not encouraging the Jones Day to broaden their application, but actually the application for the removal of a liquidator is brought under Article 103, not 102. I said I'm not encouraging the significant broadening of the application, but I think they ought to refer to that in their application notice as well, because that is actually the jurisdiction for removal. But the other points they want determined under 102, and as I've explained to you, we want some finality on the things that affect the liquidation, including this interpretation of the settlement agreement. And can I just, on the timing of the production of the settlement agreement, I mean, we really need to see this document. They should, I mean, as far as we're concerned, they should provide it today. So I'd be grateful if Ms. Martin could indicate if that's a problem. If not, we'd like it by close of business today.
We would just like an order from the court before we provide it.
Yeah, all right. Well, I'll make an order now. So can you produce that today?
Yes, Your Honor.
Very good. Well, that's easy. Court orders production of the document as being a matter referred to in the pleadings.
Could we address our document request as well, which is only 2 documents?
Yep. Well, we'll come back to the funding agreement in a moment. Don't worry, I've got the agenda here, but we can sort out most of this without difficulty once we've sorted out the other timetabling issues, I think.
When it comes to the order, could we just ask for the confidentiality provisions that we requested in our draft order to also be imposed?
Do we need anything extra beyond those which apply in any event?
That any use that the liquidator or his counsel make of it is solely in relation to these proceedings. I don't want them to go off and talk to the Al-Kharafis about it.
But so I'm a little bit mystified by this point. I mean, we can only use any material we get for the proper discharge of our functions, and we're subject to obligations to the court on that, as well as under the as well as the position as an ordinary litigant under the court rules. But I wouldn't want that fettered. I mean, we have to be able to do what we think is proper for the discharge of our functions. And the suggestion, there was no suggestion when Jones Day wrote to the court, I think yesterday, saying that they were happy to give this by consent if there was an order. There was no suggestion then that there should be further strings attached. I think the first strings appeared in my learned friend's skeleton and draft order. And I don't see they're appropriate. I'm not trying to be difficult, but I just don't see why the liquidator should be fettered, especially in circumstances where the consequence now of all of this is very serious for the liquidator.
Well, as a matter of ordinary practice, if something is disclosed in litigation, it's disclosed for the purposes of that litigation and for use in that litigation. So far as the Kharafis are concerned, they are party of the settlement agreement anyway. So I can't quite see if it's necessary to talk to the Kharafis about it in the context of the litigation funding or whatever, for the purposes of the litigation. There's no breach of confidentiality anyway. So what's your concern, Ms. Martin?
We would just ask for the conditions that we put into our draft order, which I have here. It really is just, it's a protective measure, Your Honor. I think the court is quite aware of how litigious the Al-Kharafis can be, including the fact that they got sued by their own litigation funder in the last litigation. I would envisage that any court order referencing disclosure of the settlement agreement itself that is made public would lead to a letter from them probably tomorrow. And so I'm happy with this oral order. It's obviously on record, it'll be part of the transcript, but I would ask for it to just not be referenced in the public record.
I'm sorry, this is not a hearing in private, this is a hearing in public. And we've been discussing this agreement. The court is, we were just discussing earlier about us having to write to creditors to notify them of this application. It's unreal that the basis of the application to remove the liquidator should then be withheld. I'm not saying from the Kharafis, I'm just saying from the body of creditors. So I don't quite understand my learned friend's concern, but they want to rely on this agreement. It is one of the core bases for their application. We can't now essentially keep it quiet that is what's being discussed today.
Well, it seems to me I shall make an order, which will be an order in writing. At the end of the day, the court will order that this document be disclosed, and it seems to me it'll be subject to all the usual restrictions that apply to any document that's disclosed in litigation. I mean, to the extent, once the court has made that order, the Kharafis can't have any complaint about it being disclosed, and indeed, as the authorities show, you're entitled to disclose even where there's a confidentiality agreement, where it's necessary for your own protection and of your own rights. So I can't quite see the problem, Ms. Martin. It seems to me on the face of it, if the Kharafis prove too difficult, then we'll have to deal with that, cross that bridge when we get there.
Thank you, Your Honor.
All right. Just to revert for the moment, my provisional view, Mr. Shivji, is that the liquidator ought to give notice to the body of creditors of this litigation, so that if people have any desire to come along and be heard, I'm supposing the whole body of creditors rise up and say this is outrageous what the liquidator is doing. We had no idea he was doing all this. We have no desire for him whatsoever to pursue the defendants. Alternatively, we want him to pursue Mr. Walia and ACCL and everybody else, because they were all doing it. Those are all potential options. Now, in reality, almost certainly none of them will have any interest at all, because they can't see any money in it for them. One suspects, the only people who are really interested in this at all are the Carafis, ACCL, and the defendants. I can't see anybody else who's really got an interest. Not enough money otherwise, is there?
We're obviously here to make recoveries for the body of creditors.
Yeah, sure.
The body of creditors needs to know if there is an application to remove us, right. And they ought to have the opportunity to participate. If they can satisfy the court, they ought to. And what my experience, subject to your lordship's view, is that what they're being asked to do, what they're being told is there is this application. If you want to come and participate, you will need to get permission to appear, but you can try. But it does, what it doesn't sort of lead to is a sort of general town hall meeting about the direction of the liquidation. It's very much, these are the issues that the court is determining. If you want to make representations, you can. And it is. I mean, I've had plenty of cases where that's happened. Most of the time, your lordship's right, that the response rate is poor. But occasionally I have had hearings where suddenly you've got a dozen legal teams in the room and everyone has a different view. So but that's more the Lehman side of things than probably this. But we accept that. I mean, my client, I've just had an email from my client's lawyers saying that they're content that we should give notice. So we will consider the appropriate form and get on and do that, and we will notify the creditors of the hearing date, which is probably the key milestone.
Yeah, I mean, the reality is that the rest of the creditors, it's not a very big amount of money involved, is it? So that's why I think in the end they're not going to be interested.
Well, we'll see. It's a matter for them, but we, as an office holder, we need to tell them, and we'll see what they do.
Right. All right.
So I'm grateful.
Before we talk about then how strikeout things might go, shall we deal with the question of agreed directions and get those clear? So first of all, amendment of the fifth defendant's name. Permission to amend, not opposed.
Not opposed.
Can be given straight away. All right.
And my lord, just on that, you've seen what we say. We may have to come back to you later. I mean, we're not giving up. My learned friends seem to suggest that we'd somehow shut the town at this point. It is a point of real concern for us, as you would imagine why. But now is not the day to do anything about that.
No, we're just dealing with amendment for a name purpose and not pursuing any substantive issues about whether or not there's been dissipation of assets or anything else. Right.
Is there a request or a requirement for us to amend anything baked into that?
Well, I'll give permission for all the pleadings to be amended to the name of the fifth defendant as it now is. All right, so that applies across the board. The second question then is consolidation, and it seems to me that there should plainly be an order for consolidation of the two claims as they originally were put forward by the claimant, without prejudice to all arguments about validity of steps taken in relation to the service of the counterclaim and the like, so that all points are open for debate as to how the counterclaim should be dealt with if it remains in being following the determination of the application for removal of the liquidator and the like. So I'm not going to strike out the counterclaim. I'm just going to leave it as it is. and that's all an issue for the future.
My lord, would you mind on that adjourning the counterclaim to be heard, determined substantively at that hearing on the 12th of March? Because what we would like to have is an outcome on those issues, and if you're with me, at the end of that, we would be saying dismiss the counterclaim. Because what I don't want to find is that we win, and then Jones Day say the 12th defendant says, but that counterclaim is still on in some way on track, and the liquidator still is potentially personally liable. I mean, we need to have some conclusion to all of this.
Well,
I think we're back.
An argument for consequences, isn't it, in due course, and we'll cross that bridge. That's why I'm saying consolidation without prejudice to whatever may happen to the counterclaim, which one would expect would largely follow on from what is decided in the Section 102 or Section 103, as I think it would now ought to be in addition, Ms. Martin, application.
The one thing we noted with Section 103 is it doesn't make a provision for allowance of an application, which is why we styled it under 102. But we're, of course, happy to cite to 103 as well. You
just put Section 102/103, and that solves the problem, doesn't it?
All right.
OK, now the third point that I think is beyond dispute, but again ought to be quite clear, relates to the acknowledgement of service question. Now, what I think needs to be clear is that the defendant has, by filing a defence and counterclaim, participated in this litigation, and has thereby submitted to the jurisdiction of the court, subject to whatever arguments it feels it can raise in the context of enforcement of any judgment abroad. And I understand the reservation that they want to take any point that's open to them. But if you'd filed an acknowledgement of service, then the effect of I forgot which 12.9.1 is that there is a conclusive submission to the jurisdiction, and you can't get out of that by filing a defence as opposed to filing an acknowledgement of service. And I say that for the record, because it seems to be absolutely clear that you are, by filing the defence and counterclaim, participating in these proceedings, subject to all the points you want to take. But it's not open to you, won't be open to you to say in any foreign court subsequently that you weren't participating in these proceedings. You can try and put whatever reservation you want on that, but that's the reality of it. You understand that, Ms. Martin?
I do understand that, Your Honor. And
otherwise, I'm going to make you file an acknowledgement of service.
I understand the court's point.
If I made you file an acknowledgement of service, then 12.9.1 would come in straight away, and that would be that. All right.
My lord, can I just say something briefly on that? The you had previously ordered that they do. It was obligatory, not so they haven't done that.
It's odd, isn't it? I mean, I had a quick look at that order. This is the 2nd of November order, isn't it?
It is. That's right. It's page 668 of the bundle.
Yeah, and it says if they wish to defend the proceedings, each defendant must file and serve an acknowledgement of service and a defence by the later of.
Yes.
And that's slightly odd because there's no differential between the date for acknowledgement of service or defence. And ordinarily, if you put the acknowledgement of service in, you get an extra, whatever it is, 14 days, don't you, to put in your defence.
Which is what we precisely understood the purpose of that to be, is because Mr. Shivji advocated quite forcefully at the hearing that he didn't want there to be a gap between the two. So we understood that the reason for putting them both in was to make it so that we couldn't take advantage of the gap in the rules. And so we have participated by filing our defence, as the court rightly noted right at the beginning.
If I may, that statutory submission to the jurisdiction under 12.9 is important. Yes. And what we don't want to find is that the defendants in Switzerland are saying, look at the reservation we gave to the DIFC court, which is in their pleading, paragraph 4, and we haven't filed acknowledgement of service, and that gives them some greater benefit. So it seems to us that either they filed acknowledgement of service as they were required to do under your order, or that if your lordship is content to do so, there is a declaration in today's order that simply recites 12.9 and says that the effect of them filing a defence is as 12.9 provides. So it's just recorded in an order that is where we are, and that's the only benefit we really seek to achieve with all of this.
Well, I understand that. The question is whether Ms. Martin accepts what I've just said, that the effect of what has been done by putting in a defence is exactly the same as if she had put in the acknowledgement of service.
Well, we understand that is this court's view of that. My instructions are to maintain the objection as to the Swiss position, both as to the primacy of the proceedings there and to the jurisdiction of those courts. That being said, we intend to fully participate in these proceedings.
Right. Well, I'm going to require you to serve an acknowledgement of service, and you'll do that within 24 hours, please.
Noted.
Okay. Disclosure of the settlement agreement we've dealt with now, and the confidentiality issue. We've dealt with the challenge to the liquidator timetable. So the next question, I think, is how to deal with the questions of strikeout. Now, there's a question of strikeout of paragraph 158 of the defence, because it's a bare denial. Can I tell you what I think about that, Mr. Shivji?
Yes, I mean, my lord, if it helps, before you do, there is this goes hand in hand with the strikeout, because the same points that they haven't particularized in their defence, they are seeking to strike us out on. So I would like you to hear me on that. And I should say, I'm not trying to get that paragraph struck out. I'm trying to get particulars of their defence. So I'm not, your lordship might have views about the mechanism for putting pressure on them to give particulars of their defence, but I know that sometimes, striking is obviously an unusual remedy and only to be exercised cautiously. So the focus for me is not strikeout. The focus is on me is getting their compliance with 17.27. Now, if your lordship's with me on that, then yes, please, by all means. But if you think it's useful for me to advance my argument a bit further, if you're against me, then I'd appreciate the chance to do so.
Well, what I was going to ask Miss Martin was really whether she wanted to rely on anything extra or not. Obviously, no request for particulars is really possible of a paragraph of that kind. The real question is whether or not Miss Martin wants to rely on anything other than what has been so far pleaded, or whether she wants to give any further particulars in relation to all the points that are raised in paragraphs 126 to 174 of the particulars of claim.
I think we would say two things in response to that, Your Honor, and that is, if it is absolutely necessary, we can add a statement that we incorporate by reference all of our pleadings in the prior 157 paragraphs, which are extensive, and also that the paragraphs referred to therein in 158 are all their legal pleadings, which are subject to this strikeout application.
But it goes a little bit further than that, I think. I mean, it's quite plain in a sense that you rely on everything that's gone before. So repeating in paragraph 158, we rely on paragraphs 1 to 157 doesn't necessarily assist. I've read through each of the paragraphs which relate to relief sought, dishonest assistance, plead facts of dishonest assistance, unlawful conspiracy, basis for additional damage, fraudulent trading, transaction in fraud of creditors, transactions in undervalue, breach of duty, misfeasance as directors, claims for company property, and so on. And what you've done is not to give a bare denial, because it isn't a bare denial. You say no scheme, no transfer, no unlawful activity, so ergo no damages. But there are no reasons beyond that given. And what the rules require is that you should give reasons for what you say. And the question, therefore, is whether there are any additional reasons upon which you would wish to rely above and beyond what you've already pleaded in relation to any of the particular allegations or courses of action that have been put forward. That's the question that I need to ask you, because if you want to rely on anything more, then you do need to plead it, and you'll have to give some particulars. If you're happy simply to go on what you've done without raising any other reasons for objecting to what is being put in the balance of the particulars of claim 126-174, then it can stand as it is. So I'd be putting you to an election to decide that.
Well, our belief at the time, Your Honor, was that we had drafted complete defenses, but if I'm being offered an opportunity to revisit pleadings that were put together over 3 weeks over the holidays, then I'd certainly think it's probably worth our time to do so, and we're happy to do so.
I give you 7 days to produce any further particulars that you wish to give of the reasons why you resist the pleas made in paragraph 126 to, I think it's 174, isn't it, Mr. Shipji? I can't remember where your pleading ends. Let's just check.
That's right.
The one thing I would like to raise is that we would anticipate that the consolidated particulars of claim would change in at least some form following strikeout, and so to us it would seem
they may do, but you know, we need to have the fullest case that we possible at this stage. And yes, there may be amendments and there may be costs of amendments and so on to deal with. But as I say, the point is, and I shall make this will come in the order, and we'll draft that in a moment. That within 7 days you should produce any further particulars of any reasons that you rely on to contest paragraphs 126-174 above what you've already pleaded in paragraphs 1 to 158. Okay, and you can decide that whether you want to or you not. You know, you may say, well, that's fine. We're quite happy to rely on our basic case: no scheme, no transfer, no unlawful activity. End of point. Fine.
We note that. We would note the procedural irregularity of what they're requesting, because under at least the English CPR, if strikeout were filed, then the defenses wouldn't have been filed and the claimants wouldn't have been entitled to this additional information in any event. Happy, of course, to have this additional opportunity, but we do consider it unorthodox.
We'll come back to that in the context of strikeout, but in the circumstances where you have pleaded, then it seems to me we need a full plea, and actually it's going to help everybody to know exactly where we stand. You know, the more information that's out there and the less that's hidden. I'm very keen that this matter should not be delayed beyond what is essential for the purpose of the proper conduct of the proceedings. It's a matter that's been much delayed in any event, and there are arguments about that and who's delaying and whether that's for what reasons. But let's see if we can get on with this and deal with this as fully as possible. All right, so that'll be part of the order. Then where do we go next?
So that, I think, leads us into
takes us to the question of reply and strikeout.
Yes, and it's really we say a manifestation of the same point. I mean, it's the application notice in support of the strikeout is very dense and does. I mean, it's quite difficult, in all honesty, to understand the full scope of it. But as we understand it, it is intended to strike out the entire action on all courses of action in relation to all allegations. And that's your lordship will have views about how achievable that is in any one case. But anyway, that is what they seem to be trying to do. Now, I understand the role of a witness statement is not to rehearse legal submissions, and but in relation to an interlocutory application, I mean, your lordship will have a view about how parties strike that balance, and actually that rule about a witness statement only containing evidence is interpreted quite broadly in the context of this sort of application. My understanding is that you would need to set out the proper basis in your supporting evidence for your strikeout application and explain to your opposing party what it is, the assault that they would need to meet, so that the application is fairly articulated, parameters properly set, so that the responsive evidence can hit the right notes, and then the application can fairly come on at a hearing. Now, we say that because of the breadth of their application, including on what appear to be factual issues, it is particularly important that we understand what we have to meet. And the position is made worse by the fact that these seem to cover exactly the same grounds as those paragraphs of the defence that they didn't plead to. So you can't discern from the defence what their case is, in particular on the allegations of fact, which they've not pleaded to. And then you can't discern from the strikeout application and supporting evidence what their case on those facts is either. So this is something one won't find in the court rules or even in a book. This is a point of practice and experience, and your lordship will have your own view about how far they need to go. But we would say that Devonist 7 isn't anywhere near good enough, and they've got a choice. They either confine themselves to the points made in Devonist 7, which is effectively nothing, or they have another go at their evidence. And the RDC requires that all evidence in support of an application is filed at the same time as the application. So what they can't do is hold back their points until reply evidence, if that's what they're trying to do, and then dump it on us then. They need to have cards on the table approach now to explain properly the technical basis for the strikeout. They don't need to be reciting lengthy authorities or anything like that. I know it's unusual to reference an authority in a witness statement, but actually in this sort of context, or if you're looking at an application for permission to serve out, your witness evidence would actually be quite technical. It would have to properly explain both the legal, factual basis for a position. Again, just cards on the table so that it could be understood. So, I mean, your lordship will have a view on that. I'm not trying to do anything unorthodox here, but we're heading towards a 2-day hearing to strike out the entire action on our very lengthy pleading, where their defence doesn't articulate a coherent defence, where their evidence doesn't explain their position, and all we're left with is this very dense and difficult to follow application notice. And then can we just look at a few parts of the application notice? I don't want to labour the point, but the application notice is really difficult, we say, to follow. Sorry, apologies, one moment, let's pull my note up. There are all kinds of points. Just to pick up a few, they sort of make repeated reference to a lack of particularity in our pleading, but we don't know, they haven't actually identified the particular paragraphs, and even then they haven't made a request under Part 19 for further information, which would ordinarily be required before you try to strike out someone's case on a lack of particularity. They then make it, so that was 1A. 1B, they make a complaint about the relationship, the actions of third parties and the relationship managers and clients break the chain of causation. That seems to be, I think, a factual point, but again, we don't understand why those things break the chain of causation. It would need to be explained with evidence. They then say at 1C that we lack the statutory authority to recoup business. Again, I understand that's primarily a legal point, but again, it would need to be articulated so that we could understand it and then decide whether we had evidence that we wanted to file in order to deal with that. And then going on, they go on to deal with the lack of fraudulent intent and purpose. And they say they various references there to the purported use of confidential information. Is it that they're saying they don't accept that was used, or that it wasn't confidential? They then give there are various pleas about the facts, but again, not supported in any of the evidence. Then they go on to deal with the failure to sell the business, and they say the directors didn't have the power. Again, that's not set out properly in the evidence. They set out factual points about how a sale might have been conducted. So, I mean, we could go through this line by line, but your lordship sees the point that really, in relation to every complaint here, it's not clear whether it's a purely legal point or a legal and factual point. even if it was a purely legal point, we would need to understand the premise sufficiently so that we could work out what factual evidence we wanted to apply in answer. And the reason we say that it's worth getting to grips with all this now is because the substantive hearing will be a shambles if the case doesn't really emerge against us until skeletons. And then your lordship will be put in an unsatisfactory position where we're filing additional factual evidence and possibly further skeletal arguments, etc., all of which I think will make it less satisfactory for the court to resolve. So, my lord, should I pause there? I can obviously spend a bit more time developing it if you want, but that's in a nutshell our position.
Your Honour,
I've been through each of the grounds. Ms. Martin, the first thing is this: that on the face of it, you say you've filed the evidence upon which you wish to rely. There is obviously no requirement to set out a legal argument, and I've been through each of the various grounds, many of which simply raise factual issues, which you know as well as I present real difficulties in the context of any strikeout or summary judgment. As soon as you get to a factual issue that the court can't deal with without proper evidence, there's no room for summary judgment or strikeout. So the real question is, have you in fact filed all the evidence on which you wish to rely or not? Devonish 6 plus exhibit is what there is.
One thing I would say is we're not withholding evidence in the hopes of ambushing them with it in any reply evidence. That is absolutely not the case. We believe we've filed all evidence on which we intend to reply, but we would of course not like to pretermit the ability to submit reply evidence. Could I speak to this, Your Honor, because what Mr. Shivji is saying here is it dovetails with a repeated problem that we've encountered in these proceedings. And that problem is this: every time that the claimants say that they're surprised by something, that they didn't know about something, that thing that they claim not to have known about is the subject of without prejudice correspondence. And so we're left in this position where we can't defend the fact that we've told them because they're making these statements and then cloaking them under without prejudice privilege. Now, that's actually not an allowed use of without prejudice under the rules. But if they continue to do it, I am going to make an application for the disclosure of the documents on which we rely. Now, if they need an explanation as to what these strikeout applications are all about, I would refer them to letters from Clifford Chance dated 30 May 2022 and 17 November 2022. Which set out in great detail, and what the bases of these. They have citations in them. They discuss the legal grounds. None of this should come as a surprise to them. So we believe that we accurately and succinctly, as the court wants, but in enough detail that they could be understood, stated our legal grounds for strikeout. And there are some of them where there are some facts involved because, for instance, where he says he, that he lacks certain information, we know that there are certain gaps that they just can't bridge on the facts. We've discussed the powers of the directors ad nauseum throughout the jurisdictional challenges. That's been the subject of discussion for a year. I don't understand why they're saying that they don't understand it as they read it in this application notice. So they have plenty of information on which to respond. And by coming to the court and saying that they don't, it is them who is tacitly referencing this without prejudice correspondence. And I genuinely want that to stop because it has happened on multiple occasions.
So,
well, I think it's what you're telling me is that there is no more primary evidence upon which you wish to rely in the context of your strikeout. Of course, if you see evidence that comes back that needs a reply, you'll put in a reply.
Correct.
But I'm certainly will come down like a ton of bricks if I discover that your reply evidence constitutes a whole lot of new material that isn't truly a reply and ought to have been there in the first place. And the one thing we want to avoid is that having set up a hearing, it all has to go off because you produced a lot of late evidence. Mr. Shivji then wants an opportunity to put in something by way of reply. So if you're telling the court that's all you wish to rely on by way of fact evidence, then the court will simply say that that's okay. And you take the risk then in relation to what currently appears in your documents. You not being able to rely on without prejudice correspondence. You can't show that to the court.
Of course
So
not.
that if you whatever you want to produce has got to be produced by way of evidence in the ordinary way. There's only one particular paragraph that I was troubled by because it seemed to me there wasn't an adequate explanation, which is the little c, which is the liquidator lacks the statutory authority. I have no idea how that could possibly be. I mean, on what basis do you say that? That does seem to me to require amplification. We can go through each of the heads in a moment, and maybe we'll need to, and I'll tell you what I think about them, so that any decisions you take are being taken with your eyes wide open, if I can put it that way.
Absolutely. And of course, if the court is offering us an invitation for an additional 7 days to go through and make sure we've included every last document we intend to rely on, we're happy to take that opportunity. We do want strikeout to proceed apace, and so we wouldn't want any such opportunities to derail any schedule. But we are of course happy to hear the court's views on.
Can you tell me what the basis of C is?
The basis of
statutory C.
Sure.
The liquidator lacks statutory authority.
Well, the statutory authority, as we read it, as contained in the insolvency statute, goes to recouping the assets and the property of BSA. It doesn't go to recouping the business, which is a much woolier concept. And even where they plead that the nature of the business, and I don't think this is quite right, but we'll go with it for a minute, where the nature of the business is the relationships with clients, that's not something that can be recouped.
Well, I mean, let me tell you what my understanding is. I understand your issues about inadequate particularization of transfer, property, assets, business. But the bottom line is this, isn't it? That as it's pleaded, whether rightly or wrongly as a matter to be determined, but as it's pleaded, there was an inducement to break contracts, contract being a shows in action, contracts with relationship managers, and then relationship managers who contacts with the clients. So we are talking about contracts, essentially, aren't we?
If that's what they had pled, that is what we would be talking about, but they don't mention contracts with clients. They don't mention employment contracts with RMs. That is not mentioned anywhere in their pleading.
Well, that's exactly what I've understood as being meant when it talks about relationships, but that's a question for you to develop in due course. But what you're really saying is that it's the same point that you've made about inadequate particularization of the terms property, assets, and business when you say it doesn't make sense. I think I'm going to require you to spell out what you mean by a little c. The liquidator lacks the statutory authority to recoup BSA's business. If you're saying there's no business to be recouped, that's one thing. But on the face of it, if there are assets that have been dissipated, then the liquidator would be entitled to recover them, and his statutory authority isn't in doubt unless and until he's removed.
Not in relation to assets. It's not our case that he's not entitled to recover assets. That is part of a statutory authority, as is property, not business.
Right. So is it the same point that's made earlier on about property, assets, and business?
It relates to the same problem, but I don't think it's the same point. This is a pure point of statutory construction.
I'm sorry, but are you saying that the word quote business unquote doesn't represent assets? Is that what you're saying?
We would say that the assets are recorded on the balance sheet and there's not a line item that denotes business. Assets is it's an accounting term, and it's well understood.
The goodwill of a business is not an asset. Is that what you're saying?
Not one recorded on this balance sheet. And if the goodwill of this particular business were recorded anywhere, it would have been recorded on the books of the shareholders, not on its own not on its own books. Goodwill is a term that it's an M&A term that goes to what is recorded by the purchaser, and so it doesn't really relate to any of the pleadings here.
Right. Okay. Well, let's just go through your different grounds to make sure we've covered the position, and that you can tell me if you want to say anything more.
Sure.
Okay. Do you think the form of the application notice that the court uses is not very helpful in this respect, because it doesn't sort of set things out in a nice, easy way with different sections and so on. It all just follows one from the other, and trying to subdivide then becomes a problem.
It wasn't nicely formatted when we did it on our
systems
before we copied it.
It's the way it works when you use the template, I'm afraid. It's one of those things. Not disclosing reasonable ground for bringing the claim have no real prospect of success. Understood. No problem. Everybody understands that. That's nice and easy. Fraud claim lacks particularity. That's your next point, right? That's clear enough, seems to be. Inadequate particularization of business, property, or assets transferred. That's the point we've just discussed.
Correct.
I'm just working down these to make sure that I'm not missing anything. Right? Claimant's interchangeable use of terms property, assets, and business without defining or the concept of giving effect to their common meaning underscores the lack of particularity. What you're really saying is there's no proper allegation of dissipation of assets, right?
Correct.
Yeah. Nothing more to it than that.
There's probably more nuance to it than that, so I don't want to say nothing more, but that is the gravamen of it.
Give us a quick nuance then.
Well, again, it goes to whether or not the business can be considered an asset, which, at least according to the balance sheet, unless they're relying on something else, it's not. And again, where they refer to the repeated use of the passive voice, they don't say who's doing what. It's just sort of like the business went away, and we're not really accusing anyone of doing it, except that we're accusing these defendants of doing it. They don't say who did what when.
Well, they are saying, aren't they, that you suborned the relationship managers and thereby the clients, because isn't that what's being said?
Not in their factual pleading. That is the inference that it is asking the court to adopt in the end, but that's not what their factual pleading says.
Well, inasmuch as they ask the court to infer that's what happened as a matter of fact, maybe right, maybe wrong. But that seems to me to be the case. Anyway, that's the point you're taking. Understood. Next, the action of third parties breaks the chain of causation. That's the same point that you basically make throughout your pleading, that the relationship managers and the clients had autonomy to do whatever they wanted once the business was breaking up. That's basically the point, isn't it?
Yes.
And that's it. I mean, it's not really a break in the chain of causation. It's simply saying there was no inducement, there was no dissipation of assets, because these people did entirely what they were free to do as a matter of contract and as a matter of law. That's what it comes to, isn't it?
I'm not sure I'm ready to give up the point that it breaks the chain of causation, but I think that the court understands our point.
You're saying there's no breach?
Well, we're saying there's no breach. I suppose as in the alternative position, we're saying even if there is a breach, the chain of causation is broken.
Okay, that's a bit more difficult to see that, because if you procure someone to act in breach of contract and so on, then I can't see quite how the break-in chain of causation works. Either they're free to do what they want to do because the relationship managers wait for the relevant period of time to expire in their non-compete provisions or whatever after termination, and then the clients do whatever they want and they're not bound by anything either. That's one thing. There's simply no breach there, so you don't get into causation. If however you the defendants individually and BJSS as a body has procured parties to breach their obligations, whether they're relationship managers and the business is taken away unlawfully, there's no break into chain of causation at all. Anyway, there it is. We understand the point you make, and we can deal with it.
I want to make sure we're talking about the same breach. Again, I don't read there to be any allegation of inducement of breach of contract by the defendants of any contracts with the clients or any contracts with the relationship managers. I read the breach to be the breach of the director's own duties. That is the breach as I read the allegations.
Yeah, but the breach of the director's duties is in dissipating the assets which are constituted by the business through the relationship managers with the clients. Isn't that the basis of it?
That is the basis of it, but it's still on my reading of it. And maybe perhaps Mr. Shivji can weigh in since it is his pleading. I've studied it in detail and I just don't recall anything about relationship managers or clients breaching contracts or inducement thereof.
Okay. All right. Well, at least we're understanding the point you're making, which is the key question for current purposes.
And my lord, just on, I'm sorry to interrupt, but just on that, I'm understanding from my friend that there are no other actions of third parties relied on aside from those mentioned. So that, what I want to avoid is that I think this is a useful discussion, and I'm grateful for your lordship for leading it. But what I don't want to find is that later on something doesn't come up in this hearing, but then the applicants try to rely on it. So my learned friend has to get it on the table, everything that is in play, because obviously we'll look very carefully at the transcript of this hearing to make sure that we've understood the points being advanced.
Your point being it's including the relationship managers, RMs and clients. So no other third parties being referred to.
Yes,
is what you're interested in.
My understanding is that what she's saying is that in fact you can get rid of the actions of third parties and just say on this point it's the relationship managers. Yeah.
I had understood that to be the guts of what's being said. Are there any other third parties you rely on, Miss Martin, apart from relationship managers and clients? It's their autonomy, as you put it. They can choose who they want to go with.
That is what we had been thinking at the time. Before I take a position that limits my client's rights, can I go away and think about that one?
Well, I'll give you an opportunity to come back with any further particularization, but I think it's useful to go through this to see just where there may be room for misunderstanding and in order to try and avoid it. Yeah, the essential point that I've got out of your defence is that these parties were entirely free to do whatever they wanted because the business was breaking up. The shareholders decided it couldn't go on, and at least sub silentio. Well, no, I think you say it expressly. Mr. Whaley and ACCL were doing exactly what you were doing, and they were all trying to get the business into their own hands. Now, on the face of it, that may, if both shareholders were trying to do that, they may both have been acting in breach in the sense of trying to dissipate the assets of the company in order to, or with the effect of depriving a judgment creditor of the fruits of his judgment. The point that you make about ACCL and Mr. Whaley and co not being sued may be a point that would go to the failure of the liquidator to fulfill his responsibilities wouldn't impact on your liability. The fact that someone else is liable for doing exactly the same thing doesn't let you off.
Well, it goes directly to intent, though. If they are going to allege that we had a fraudulent intent, and let's recall that this is not simple breach. They can't prove their case on simple breach. They have to prove it on the basis of dishonesty, where there is objective indicia throughout the record of our clients attempting to preserve the assets of BSA, and similarly objective evidence throughout the record of Mr. Valia trying to dissipate them. It absolutely goes to intent, and it does bear on our client's liability.
Well, I understand what's being said about intent, but if one comes down to the bottom line question, which is whether or not there was dissipation of assets, then one has to grapple with that. At all events, we understand what you're being said. The next point, point you take is lack of fraudulent intent. Well, that's a question of fact.
May I go back to the prior point for just a moment, Your Honor, because I think it's an important distinction that this is where we need to be really careful to be very granular about which actors we're alleging did what, because a shareholder is entitled to make these corporate decisions. It's entitled to wind it up. It's entitled to make internal decisions that affect the profitability of it. It's entitled to make internal decisions that affect the desirability of what ends up being we'll call it a competing business for the sake of argument here today. In the same jurisdiction, it had those rights. If any prohibition on the shareholder to affect those rights would have been contained in the articles, in the business agreement, or in the other corporate documents. None of that was the case here. So it's a different question of what the directors can do. But again, this is where we believe the sort of woolly pleading, the passive voice, the failure to identify particular actors masks a lack of particularity on their side as to who did what and whether or not it was truly a problematic breach or a dishonest breach. Yeah,
well, again, it's not for me at this stage to interpret Mr. Shivji's pleading, and he can say what he wants about it. But the essence, the point is that what one or both shareholders appear to be doing on the claimant's pleading is to procure the dissipation of assets to the prejudice of a creditor. The liquidator, he is the company. The shareholders may both be acting entirely improperly in relation to the winding down of the business. And of course, there may be a point about why you sue one and don't sue another, and there may be good reasons for that. Who knows? And that may go to your issues with the liquidator. But so far as liability is concerned, if there's a procurement by a shareholder of the dissipation of assets by the company by getting the directors to do what they want them to do, there's a problem, isn't there?
If they cause the directors to act in breach of their duties, yes. Yeah. If they take lawful steps provided for within the corporate documents that are not dishonest and that are not fraudulent, then I would debate my opposing counsel on that.
Yeah, well, that comes back to the unlawfulness, doesn't it?
Yeah. It does.
All right. Liquidators lack statutory authority. We've discussed that. It's not the liquidator's authority that you're interested in as much as the question of, quote, business, assets, property, and so on.
Well, this is one where I believe the assets and property stand in a different category than business.
Yeah, I understand. That's the point. It's not the authority of the liquidator per se.
Correct.
Right. Okay. Lack of fraudulent intent. That's a question of fact. Use of confidential information. There are fact questions there as to whether or not there is truly confidential information which was available in any event to BJSS and Mr. Sassoon. So that's the issue there that you're raising, is it?
Yes.
You're saying it's not actually confidential information.
Correct.
Right. Then failure to market the business for sale. You say the directors had no power to sell. The sale was impracticable for any number of reasons, and you rely on the business agreement about what happens when the joint venture ceases operations, right?
And the reserved matters provisions, I believe.
Under what?
And the reserved matter provisions under the.
Yeah. Well, we come back to the same basic point about whether you're procuring something unlawful in the context of dissipation of assets by each deciding that you can take the client relationships off where you want to take them. Anyway, there it is. Understood. Failure to particularize fraudulent intent is the next bit, a third the way down the following page. Oh yes, well here you have the very point I raised earlier on about legal advice. The fourth defendants did not believe, nor ought they to have believed, on the basis of legal advice received by BJSS or BSA, that BSA was insolvent, imminently insolvent, or had no realistic prospect of avoiding a full insolvency process. Now, you're going to have to make a decision as to what you do about legal advice there, for the reasons I've already given.
Some of that is joint advice with BSA, and so I will need engagement from the claimants team on whether or not they waive privilege.
It would be common interest privilege.
Correct.
Well, you've already waived privilege about the prospect of success on appeal, and indeed referred to what one of the current judges of the DIFC court said when he was counsel. All these things always come back to haunt you in later life, but there it is. But what I say, I think is much more difficult, and I don't understand. And the question is whether or not there is advice you wish to disclose in that context, as to how it can be said if the appeal was to fail, BSA wasn't obviously insolvent. If the appeal failed, it seems to me inevitable that anybody looking at it would think that the company was insolvent, wasn't ever going to be able to pay 35 million. Anyway, there it is. I say you're going to have to work out what you do about legal advice. The point, I think, is pleaded. I mean, it's there. It's clear what you're saying. But whether or not you can rely on legal advice is another question, and we won't go into that now.
Well, I would like to tee up Mr. Shivji for a response on that. I don't have an indication from claimants on whether or not they're willing to waive privilege, or if they will make a claim of privilege if we try to put something in that is jointly privileged. And it's not just that it was common interest, it's just at some point both companies had common solicitors and or counsel. I think it got divided up over time, but I'd have to go back and look at the record on that.
And do you need his consent to waive privilege in that context?
I believe they've objected to our potential disclosure of jointly privileged material at some point. But again, I
haven't looked at the law on that for a bit, so you may have to think about that. I don't know the answer. All right, where do we go next? Time bar, yes, okay. Assumed duties not owed. Dishonest assistance, knowing receipt. No cause of action under DIFC law. Well, that's quite an ambitious thought. Failure to particularize the receipt of any company property to which a fiduciary due obligation attached. That's pretty much the same point as earlier, save with a nuance. No claim for unlawful conspiracy. Well, that's very ambitious. Fraudulent trading. So basically, failure to state what was fraudulent trading, failure to state what the transaction was that was in fraud of creditors, back to no intent to defraud, and failure to particularize what property was misappropriated or put out of reach of creditors. No claim for breach of duty of misfeasance in DIFC law. Well, again, that's ambitious, but it's clear. What's the I'm at the bottom of the penultimate page now. Vicarious liability. I'm not sure I understand that point at all. What's the point you're taking there about it not being a fraud claim?
Well, again, because it's not a fraud claim, it would be subject to the 6-year statute of limitations and therefore could not be brought on these facts.
But if the director himself is being fraudulent, what's the point you're taking?
Again,
if someone is liable for him vicariously, aren't they tainted by the fraud so that the fraud limitation period applies?
It's a legal point, Your Honor. I mean,
okay.
we'll argue in due course.
Maybe a bad point, but it's a legal point. All right.
It may be a bad point. We will drop if it is truly that bad.
Well, I think it's not for me to say anything at this stage, really, but it's as I've already indicated, as soon as you get into facts and factual issues, I mean, there's no way the court's going to be able to decide this on a summary judgment or strikeout basis. Anyway, there it is. I think they're clear enough. Relationship of individual defendants and BJSS are governed by Swiss law. Yeah, but okay. What about the relationship between BSA and the directors are governed by English law? That's simply not right, is it?
It is under the corporate documents. The corporate documents are under English law, and they set out the existence of directors. They set out the duties of directors. They set out the reserve matters. There is no separate contract between the directors and the company, and so our view is that the existence of those directors' seats is a function of those corporate documents and therefore exists under English law.
Well, I suppose there are two things there are. One, they're contractual duties that may be governed by English law, but the other is because it's a DIFC company, their duties will be governed by DIFC law. And the question will be how the two interrelate then, will it? And if there's any material difference, which there may not be, I don't know.
There may not be, but in any event, the burden is on the claimants to have pled it.
Okay, well, that's understood. That's what you say. Failure to plead particulars of loss. And particularly, you say they've not articulated what proportion of revenues assets can be attributed to the clients they claim were transferred. This is the same basic point, isn't it, that you were making earlier about what it is that has actually been lost in terms of business or assets or contracts or relationships or goodwill or anything else?
That's part of it, but to put a finer point on it, I would just invite the court and the parties to look at the 2013 financial information, in which the profits of this company in 2013 were $750,000. Now, its legal spend was $2.5 million. So, but that's if this company were to continue and meet its regulatory capital requirements, it would have taken it 100 years to be profitable enough to meet this judgment debt. And so to say that the deprivation of, and frankly, anything from this company could ever amount to $75 million, they're talking about 75 years worth of business on the financial statements from that year. Now, this is all very back of the napkin math. I would reserve the right to plead it more articulately going forward, but it's just their damages claim just doesn't even pass the laugh test.
Yeah, okay, well, I understand that. Obviously, once you get to damages, you're into accountancy evidence of one kind or another. But there we go. Understood. That's what the point is. All right. Well, my view, something that Mr. Shivji wants to say by way of response is that there's what's being said is clear enough. Now we've been through all the heads of claim and clarified in particular the statutory authority of the liquidator point. Have you any real difficulty in grappling with that, Mr. Shivji?
So we've obviously followed very carefully this exchange, and I've found it useful. I mean, my learned friend is stuck with what she's said today. So what the concern I have is that this application can't balloon later to raise points that haven't been articulated, because then we would not have had a chance to deal with them in evidence. So
Yeah.
I'm content to proceed on that basis. Today's exchange has revealed, I think, that nearly all of their points are points of submission. So they don't, these are actually, the way they're articulated here, they're not proposing to deduce any further evidence on them.
Right.
They want to make a submission about how the case has been pleaded and whether it's sustainable on its face. That your lordship will have to decide later whether that is viable in these sorts of allegations. But on that basis, we're happy to proceed. I do have some concern that actually a lot more detail will emerge later, and that can't happen. And my learned friend's point that this has all been covered in without prejudice correspondence, I say nothing about the contents of that correspondence, but of course that is no answer. It is no answer. I sent you a letter a year ago without prejudice that told you, explained all this. I mean, they haven't put on record in open correspondence in these proceedings any of these points in proper detail. So that is why we are concerned about this. And I wonder whether the appropriate course is that we've got the transcript, we hear what's said, they're committed to that. We'll go ahead with the evidence. They've filed all the evidence they want to rely on, unless Miss Martin tells us there's more evidence to come. But there needs to be sequential exchange of skeleton arguments so that they go first. And I might well need a material period between getting their skeleton. I maybe a couple of weeks that I need in order to actually see what they've said and then respond to those arguments, given that this is potentially an assault on the entire action. And as your lordship have noticed, there are issues here about whether causes of action even exist and what their history is. I hope I won't have to go into all of that, but I would at least have the opportunity to look at it and look at it with their skeleton.
Your Honor, I'm grateful to be supported by very competent colleagues who passed me a note as we were also helpfully going through it and said there is more evidence we could put in. And so we would be grateful for the opportunity to do that. As we said, our priority, just as their priority is for the case for removal of the liquidator to go forward quickly, our priority is for this to go forward as quickly as possible. And so we just ask that the availability for additional evidence be timetabled as part of this process. Where the claimants have never afforded us any professional courtesies in the course of this matter, we would ask that they be held to the timetables and the heavy applications provision in the RDC. His protest, if I'm going to need a lot of time to do that, reign that suddenly when it benefits them, they're willing to slow things down. And so I would say that we don't want that delay on these matters. We would like this to progress as quickly as possible, and we would ask the court to take into consideration the claimant's conduct throughout the course of this and the standards that the defendants have been held to.
Right. Well, 7 days for you to clarify whether you want to put in more evidence.
May I consult a colleague for a moment, please?
My lord, I'll just wait for Miss Barton to come back. But actually, I'm sorry, but without wanting to be back and forth too much, I do want to say something further about this.
Your Honor, my colleague just helpfully reminded me that we have 7 days to further particularize the defenses, and then 14 days in relation to the matters to the liquidator. We consider that it would be unduly burdensome to have this running in parallel. We would prefer to further particularize this strikeout and or provide any additional evidence that we consider to be required. If we could just push the particularization of the defenses a little bit so that we're not running all 3 work streams in parallel, that we would be grateful for that.
14 days?
My Lord, actually, but before we sort of reach the final landing on this, my note at the beginning of this hearing, I thought my learned friend had said that they had filed all evidence in support of the strikeout. Now, of course, it's open to her to change her mind, and that's fine, but it does rather illustrate my concern, and it's a genuine concern. This is not just tactical manoeuvring, which is that we got the barest evidence in support of this application. Today's discussion, I think, has been illuminating, but there have been areas where there has been either further elucidation or reframing of points made in this document. I still find it rather unclear. The consequences for the liquidation, if these proceedings are struck out, is very serious. And I want to have a fair opportunity to deal with this wide-ranging attack.
Don't worry, Mr. Shivji, I have all that in mind. And bear in mind, it's not going to happen till after the 12th of March on any view, and when we can have a timetable that takes that into account. But what I'm keen to do is to make sure that we really do have cards on the table.
Yes.
Which is why I'm giving Miss Martin the further opportunity, and I'd rather give her more time and make sure that this is complete. As I understand the exchanges that I've had with Miss Martin, her case essentially turns on the way the matter is pleaded, and she's going to argue that as pleaded, you don't come up to scratch. And she doesn't make that good on the pleading, and there are factual disputes on the evidence, then, as I've said, there's really no room for summary judgment or strikeout. So I think there has been clarification in going through this material. But if Miss Martin wants to rely on any further factual evidence, let's have it out there at the beginning so everybody knows where we are. So that's where I'm going. And I'm suggesting 14 days to you, Miss Martin, but you were going to come back.
I can assure Mr. Shivji, this is really just a matter of soul searching to make sure that we've put in everything that we can put in. We did make a good faith attempt to put in everything we intended to rely on in the first instance. Could we have 14 days for both the defenses and for strikeout? So that we can, that will allow us to run them in parallel. And if in any event, the strikeout's not going to be heard until after the removal action, I don't see the prejudice.
All right. Now, let's say 14 days then for any particularization of the defence that may be desired, and 14 days for evidence on strikeout. Mr. Shivji, how long do you think you're going to need? We're assuming on this basis that you're not going to be suddenly deluged with new material, because this is, as Miss Martin puts it, a soul-searching exercise to make sure they haven't missed the odd document here or there.
Yes. My understanding of this application, as your lordship said, is it's a tack on the pleading as to whether the pleading is viable, and that's fine. What I was concerned was it was something quite different. Was a case which said the factual evidence is so clear that the court can make a summary assessment of facts against the allegations made, and that it doesn't appear to be that Miss Martin is saying that at all. And so therefore in my evidence I don't need to start trying to evidence all of the components of the case to show the court there's a dispute. I think my understanding is she's not going down that route. She's only saying, look at your pleading, it's not viable as a document. And on that premise, then I think we could get our evidence done a bit more swiftly. There's still potentially quite a bit to recover. So I worry that the usual 4 weeks for heavy applications may not be enough. And I'm also in a heavy trial next month. So I wonder whether we can ask for 5 weeks, my lord.
Well, let's put that in provisionally to see where we get to then in terms of a reply, evidence and hearing. supposing I allow 5 weeks, Miss Martin, how long will you need for a reply evidence?
We believe 2 weeks is adequate. We would just ask for enough time to draft skeleton arguments after that. In the past, we've really been pressed to get skeletons out within a week, and that's tough on our team because we are a one-stop shop and we don't have separate counsel to draft those for us.
Right. 14
And
days.
My suggestion, my lord, is that they're sequential, subject to your views.
Well, I can see the sense of that in case there's anything that arises, but let's just look to where that takes us to. So 14 days will take us to the 9th of Feb again, won't it? And 5 weeks thereafter will take us to 18th of March, is that right?
I think 15th.
15th of March, yes, thank you. And 2 weeks thereafter would take us to Good Friday, the 29th of March. So we're then looking for a date sometime in April.
Could I just remind the court that the Eid break falls relatively early in April?
Can you tell me the dates of that?
Yeah, we believe it's the week of the 8th, like the 8th through 10th, we think will be public holidays here.
Yeah. Well,
yeah, and for, as I said, my lord, my preference would be sequential exchange of skeletons. My view is one's looking really at a mid-May hearing actually rather than April, because I don't think I think this falls in Miss Martin's point that one mustn't have skeletons too close to the close of reply evidence, and so subject to your lordship's availability, I think we're probably looking at a hearing in probably mid-May-ish.
well, I'm afraid we're not. May is completely hopeless.
Right.
The reality is, I think it would have to be in. It would have to be in the week of. I think it'll have to be in the week. We're looking at 2 days for this, aren't we? So
Yes.
Realistically, it's got to be in the week of the 15th of April. Could be towards the latter end of that if you wanted. If that helps at all.
Oh, I think right now we're talking about just the exchange of skeletons, which we haven't.
I'm talking about a hearing, and then we'll go back to skeleton.
Okay.
Work backwards to that for skeletons. Talking about a 2-day hearing on, say, the 18th and 19th of April.
Is that my lord? Is that the latest that you could do? I'm very grateful for you accommodating us, but is that the latest you could do that month? Because I do worry that does put us under pressure in terms of getting our ducks in a row.
Will it?
Well, I think it will. To just Miss Martin's, I mean, I want skeletons to be sequential. If they are, then I need a bit of time to actually see what she said and react to it. And that these things all just take time. And
but if we have the reply evidence in on 28th or 29th of March.
Yes.
I appreciate Easter comes up and then there's Eid and so on. But I would have thought we could have had skeletons on something like the 15th and 17th and well, 15th and 13th and 16th, say, and a hearing on the 18th and 19th. That's what I was thinking of.
And is the following week viable for your lordship?
No.
I say that for purely selfish diary reasons, but that would be better for me if that was possible for your lordship.
And I'm very concerned that I won't have time to read the cases that Mr. Shivji cites. They are obviously quite excellent legal researchers, and it takes me a lot of time to get through them.
I can't believe this is really going to turn on matters of law that are esoteric to insolvency cases. You know, that we're looking at a strike out summary judgment case, and the principles that apply there are well known. So, you know, there's a little bit of pure law in some of the points you made about causes of action not existing in DIFC law, but I don't think that is going to require enormous degrees of research. I think actually, Mr. Shivji, I've got to go for the 18th and 19th. I can't really do anything else in this context. We'll run through all the dates in a moment, but okay. If we work on the basis of the hearing on the 18th of 19th of March, then skeletons skeletons 15th and 17th. And if you do it by close of business DIFC time, then I can read them in what remains of the English day.
I'm so sorry, Muddle. Could you just give me those dates for skeletons again, please?
That's sequential skeletons. So it's Miss Martin's skeleton on the 15th of March, April. Sorry, I'm sorry. I'm getting muddled now, aren't I? My fault. 15th of April. Your skeleton on the 17th of April, both by close of business Dubai time, which will then enable me to read them. And then we'll have the hearing on the 18th and 19th of April.
Your Honor, I'm just very concerned that receiving their skeleton the day before the hearing, I won't have time to read it, even if we receive it by or review the authority cited therein. I would really be grateful for at least a day between their skeleton and the hearing.
What about they file their skeleton on the 12th, and we file our skeleton on the 16th? Then
I would advocate for the 15th and 16th.
No, we'll need time with. I've explained, I think, quite fairly why we would need more time than that.
Let's go for the 12th and the 16th. Then you're each getting adequate time. 12th and the 16th. All right, and a hearing on the 18th and 19th. Then the only other question, we'll run through all these dates right at the end just to make sure there's no misunderstanding and everybody's happy and the order takes the form that it ought. The question really is then whether either of you wants or thinks there's any purpose served in having a reply and defence to counterclaim.
I think for our part, it makes sense to. I mean, we need to see the further particularisation of their defence on these points, and I think for our part, I think it ought to wait. I think that question should just be adjourned, maybe to the strikeout hearing for further directions. I mean, I would say that if your lordship is with us on the strikeout, then at that stage we will be asking the court to essentially set down the directions to take this matter to trial, and probably most critically to identify the trial window so that we have some sort of framework about where we go. That's obviously if I'm right, not if I'm wrong. But I think that's where, for our view, then that would be a time where your lordship could look at the final pleadings and then set up the rest of the timetable going forward.
We, of course, have quite the opposite view. Mr. Shivji has, of course, teed this up to get as much information from us as possible, as we would expect, so that he can advocate for his clients. But we would ask the court to treat us equally and to put them in a position to have to reply to the submissions that we've put in on time.
What's the benefit of having a reply? You're going to get his evidence in relation to the strikeout application, and indeed, obviously, in relation to the liquidator. You know, the essential points that Mr. Shivji has to deal with in relation to his pleading are the critical points that you've raised, first in relation to the quote loss of business, if I can put it that way, and whether or not anything unlawful occurred in the context of whatever it was that was lost in terms of relationship managers, clientele, contracts, assets, goodwill, property, however you want to put it. And then secondly, how any real loss can be said to have been suffered in any event in terms of figures. Now, as I understand it, those that raise questions of fact as well as questions of pleading, but everything else just about is a question of whether or not there has been an adequate pleading that gives rise to a cause of action that could properly be pursued. Now, if that's the case, you know, how is a reply going to help you beyond what it? I'm, you know, I don't see much in the point either way, to be frank. There'll be more money spent in producing it, I guess. They've got time to do it. Could be done along with the evidence they're going to produce.
Your Honor, in the same way that Mr. Shuji wanted our additional information on our narrative in addition to any evidence, and he says that the evidence is insufficient to understand our case. I just don't understand why that logic wouldn't go both ways. If he requires that information, so do we.
I don't think that's remotely fair. I mean, Your Lordship, I would encourage you to step back on this. I mean, you can see what's going on here. They say that our current funding for this litigation is unlawful, that the liquidation should be removed, and yet they're trying to put us to a task that will take time and money and is totally unnecessary. They have said that this case is strikeable in its current form without waiting for our reply. I'm not even obliged to file a reply under the rules. It's a matter for me as to whether I want to do one. And I'm doing one at the moment in relation to a case where they have not given any reasons, any proper reasons under the rules for the denial on any of my causes of action. So this is either an exercise designed to put my client to extra unnecessary effort and expense, in which case it's improper, or it's designed to get a tactical advantage on the strikeout, which would also be improper. So I mean, my position quite strongly is that we ought not to be put to this trouble now. They should have to take their application as they've chosen to make it.
Well, it's all rather odd, isn't it? Because in the ordinary way in a strikeout, you wouldn't even have a defence and counterclaim. but
yes,
there
exactly.
we are.
Exactly.
There we are. But I mean, in reality, I don't see much difficulty in you producing a reply at the same time as you produce your evidence. You know, the whole thing will be looked at in the round. So I think that's what I'm going to order. We'll get this case moving on as far as we can, even if some of this expenditure in the end proves to have been wasted. So reply at the same time as your evidence on the 5-week date, whatever that is, after the 9th of February, 15th of March, wasn't it, or something? Sorry, yeah, something like that. We'll get there in a moment. All right, is there anything else that we need to decide other than clarifying now the dates? I think we've been through my agenda, at least.
Could we just revert to our document request for
Yes, quite right. We haven't dealt with that. I mean, the position I think is this, isn't it? There's nothing in the rules that actually requires the production of the third-party funding agreement or ATE insurance, but it is inevitable if an application is made for security for costs that such documents would fall for disclosure. Have I got that right?
That's correct.
You have to disclose if you are third-party funded, but you don't have to produce the documents themselves. Is that right, under the rules?
That is correct according to the rules, and according to all the cases we looked at in which security for costs was examined in the context of a litigation funding agreement. The thing that the court did is examine the terms of the litigation funding agreement.
But I think on that, my lord, we can't just shortcut this without a proper application. I mean, the backstory to this is they've written to us recently to say they are in the process of finalising their security for costs application. They've only written on that once last August, and they didn't articulate a proper explanation as to why that arose or the amount of security that they're after. They need to follow the usual course with this. In relation to the litigation funding agreement, I would need to consider my position. there's authority to suggest that the liquidator is entitled to assert privilege over it or parts of it. I would want to consider that. So it's a matter for Ms. Martin as to what application she wants to make. They've told us they're finalising this application. We've suggested they send it to us in draft. They have so far declined to do that, but they can still do that. They should at least articulate their position properly in correspondence with a full explanation, and then we will consider it. So I'm not saying no, but I think one has to follow the appropriate sequence here. We can't just pitch up where they've made no application, no proper warning, and then just say this should be on the agenda and should be ordered.
I think that the record has at least 15 pieces of correspondence in which we've asked for the ATE policy and the litigation funding agreement. So to say we've only written about it once in August is patently false.
I didn't say that. I was very precise about what I said, and I said that they've only written on security for cost once, and that was back in August. That was the last occasion on when they wrote on it. And if Miss Martin wants to identify other correspondence that refers to security for cost, she can, but I don't think she'll find any. I think she'll find the most recent one prior to this week was back in August, and it needs to be done properly. I can't be bounced into an application dealing with privilege matters with no evidence, no draft order, and no proper warning for my client.
Well, the basis for the application, I think, is going to be self-evident. It's an insolvent company. They are being funded by parties who are outside of the jurisdiction, parties who have been sued by their own litigation funder for failure to pay them, parties who are known to be incredibly litigious. There's no basis for which we can assume that they have adequate security under the circumstances. And every time we have written them about this, they've just written back and said, we have an ATE insurance policy, but won't disclose the terms of the policy. So it is clear from their correspondence that they intend to rely on the terms of these documents, but they won't disclose what they are. If we need to make an application, we will. It's a nominal fee in the grand scheme of things, but it's wasteful. So what we would say about that.
Well, I understand the point, but it seems to me inevitable it will have to be disclosed if it will have to be disclosed if it's going to be relied on in the context of an application for security for costs. But I think you better make your application, Ms. Martin. And there we go.
Noted.
All right. Now, Mr. Shivji, did you make a note of all the various dates that I've given you so that we can go through them now for the sake of clarity?
I did. Yes, I did, my lord. So I'm just going back to, we can do this by reference to my draft order. Let me just grab that.
All right, that's a good idea. Where's your draft order attached to your?
It's attached to my application, so that should be C tab 4.
And I probably printed it off somewhere.
Okay, C tab 4, page 278. And I think in relation to paragraph 1, that essentially where we've landed is that the counterclaim is being adjourned to the hearing on the 12th of March, and the fourth defendant will need to issue its application under Articles 102 and 103 with its supporting evidence by the 9th of February, 4 p.m. So that is paragraphs 1 and 2. My lord, we're quite happy to put together a draft order if that would suit your lordship.
Yes, but let's just go through it so that everybody's clear and we're not going to have any further debate. So that's the 9th of February. Yeah.
So then for us to file any evidence in answer, and that's paragraph 2 of my order, and we will do that by 4 p.m. on the 26th of February.
Yeah.
Then paragraph 3 of my order, that reply evidence is due on the 4th of March, 4 p.m.
Yes.
And then paragraph 4 of my order, the hearing has been listed for the 12th of March, and skeleton arguments to be filed by 10 a.m. midday DIFC time on the 11th of March. we will. It probably is the provision for the bundle. Actually, probably is the right one there, which is the 4th day prior to the hearing.
Yep.
So
Agreed,
that's
Ms. Martin. That accords with my note.
Yes, Your Honour.
Thank you.
my lord. Then moving on to statements of case. We've succeeded on the acknowledgement of service, and they need to serve that by I think the lordship said 7 days. I think
24 hours.
24 hours. I'm so sorry. Apologies for that. I'm sorry.
Make it 48 if you like.
Well, they probably should have. Well, today's Friday. They should we say close the business on Monday the 29th?
Close the business Monday, the easiest, won't it? Yeah.
Yes.
Which will be the 29th.
4 p.m. the 29th.
Yeah.
Then moving to paragraph 6, that you've granted permission to the parties. In fact, so we'll just amend that so it says the parties have the permission to amend their statements of case.
Yeah.
And then paragraph 7, they are to provide those particulars of their denial by 4 p.m. on the 9th of February.
Yeah.
And then in paragraph 8, your lordship is directed that our defence should happen at the same time as strikeout evidence, which is on the 15th of March.
Yeah.
So then moving to, sorry, I'll just pause there. Is that no comment from Ms. Martin?
That accords with what I've got.
It does accord to our notes. If Mr. Shivji wants to consider this, I mean, we could consider staggering some of these dates so that we're not both working on multiple work streams at the same time. It's something we would offer as an accommodation if the court is amenable to it, but I don't mean to disrupt what we've already decided.
Well, if the parties later agree to some adjustment that works for them, given the dates of the hearing, that's all well and good. But we'll go with what I've ordered so far.
Okay. Yes, sorry, just on paragraph 8, just to make it clear, that was our reply to their defence. I'm not. We weren't. I just had an email from my junior saying I might have misspoken. If I wasn't. I wasn't talking about any defence to counterclaim, and obviously that's not happening in light of your lordship's direction. So if I misspoke, I'm just correcting that now.
Right.
So then let's move on to section 9 paragraph 9 onwards of the order. Again, we've been successful on these. So the defendants need to file any further evidence in support of their strikeout by the 9th of February.
Yeah.
Paragraph 10, the date is the 15th of March. Paragraph 11, the date is the 28th of March. And then the hearing has been listed for the 18th and 19th of April, and your lordship is given directions for skeletons, and that is the defendant's skeleton is due at 4 p.m. on Friday, the 12th of April, and the claimant's skeleton is due by 4 p.m. on Tuesday, the 16th of April.
Yeah.
I'll just pause there again if Miss Martin has any points.
That's as I have it.
Okay, I think I'd written down a different date than the 28th, but if everybody else has that in their notes.
It was actually, sorry, I mean, there may be a mistake. Sorry, it may actually be the 20th. I'm so sorry. I think that's a typo, and also let me just check that.
It was Good Friday, wasn't it? Was the point 29th?
Yes, it was Good Friday. Sorry, it should have been. Yes, that's right. The 20.
I think I had in my own mind, if not said that it.
Oh, I'm so sorry. I think it might. I think
Good Friday.
Yes, I think I might have made a miss. Oh, sorry, 1 second. Apologies, my lord. Yeah, sorry. Actually, our evidence. Yeah, that's right. Our evidence on the 15th of March, and then their evidence, yes, on Good Friday, the 29th of March, not the 28th.
Well, I in my own mind, I'd put it back to the 28th, but that depends whether people are observing Good Friday or not.
Yes, of course. Well, I'm quite relaxed. Oh, yes, but my junior says that the registry will be closed on Good Friday, so maybe it should be the 28th.
Right. Well, let's make it the 28th then.
I'm grateful. So that's that. And then on to consolidation. Your Lordship has made the order I sought at paragraph 13.
Yeah, and that was simply without prejudice to
Yes.
the way in which the counterclaim may fall to be treated, or words to that effect.
I mean, the way that I've subject to your Lordship's views, the language I've put there probably still works, which is that it's not formally consolidated, but it's dealt with in accordance with the procedure at paragraphs 1 to 4. And if at the end of that hearing you're against me, then you can at that stage decide what you want to do with it.
Yeah.
That
makes sense, Ms. Martin.
We just want to only have to file things once. That is our main goal with consolidation. Our goal wasn't to try and.
No, I think we're all agreed. I think we all welcome that. So thank you. Paragraph 14. Then, so that's the settlement agreement, and that's to be provided by 4 p.m. today.
Sorry, Mr. Shuji, could I just go back to the prior point? And this is literally just a logistical problem that we've had serially because we are not a party to the 2016 proceeding. And so there are a limited number of documents that we're able to file on that matter. And otherwise it's a matter of bothering the registry needlessly. And we always have great difficulty filing on that matter. So we would just ask that we would be able to file everything on the 2023 matter, even if it is an application in the insolvency proceedings. Is that agreeable to everyone?
The registry has already, I think, indicated that everything is now to be filed under the 2023 action.
Wonderful.
So that's what will happen from here on in. It's now formally consolidated. So that's where it goes, and that'll be the reference that appears on the top of every pleading from here on.
Thank you.
And then finally, my lord, we're just we're onto the question of costs, and I would say I know today's been case management, but actually everything I saw was resisted. I've been successful on essentially all of the main parts, and it does matter to the liquidator and the liquidation. I mean, separate to this, we have the constant complaint from the fourth defendant about the cost that we're incurring in the liquidation, and that we say is rather rich because those costs are in material part recently due to irrecoverable cost orders where we have succeeded but only recovered 80% of our costs, and then the rest have had to go into the estate. So it does matter. I mean, ultimately it's the estate that has to bear the costs if we don't recover them at a hearing. And we say that actually what we were asking for is very sensible. We've approached this in a very sensible way. The fourth defendant and the defendants have resisted it all, didn't want to engage properly in correspondence, including on the Article 102 point, and that's why we've ended up here. It was a sensible application to make, so I ask my cost, please.
Costs reserved, unless you want to say anything, Ms. Martin. You may be saying a lot, but I can't hear you. I'm not hearing you.
Thank you. Well, there's a bit of a punchline in corporate culture that says this meeting could have been an email. So many of the matters that were raised before the court today would have been perfectly agreeable by us, but we got surprised by them, as I'm sure the court read in the letter and in our skeleton. We would ask that the order also include a provision that we included in our draft order, that the parties be required to engage with one another. And for instance, if they come to us with a draft order to the registry with things that we've never heard about before, and we ask questions, that they not be allowed to just run off to the court and file an application, that they be required to engage with us going forward. We think that this litigation could run a lot more smoothly and a lot less expensively. This is $120,000 collective dollars of absolutely wasted costs here today. The majority of what we discussed was unnecessary.
So
I don't think that's quite right. I think we're going to have a case management conference, and it served its purpose. Cost reserved is the right order, and I encourage the parties always to talk to one another and try and agree things before making any applications to the court. But given where we were in this case, there was a need for some urgency, which fortunately could be accommodated by the court. And I think it's actually served a very useful purpose in a number of respects to clarify where we're going and the way forward. So cost reserved it is, but please talk to one another before you come to the court and if you would produce a draft order at Mr. Shivji for approval by Ms. Martin and then by the court, that would be very helpful.
We'll do that. And my lord, just to pick up on Ms. Martin's point, I'm very grateful that your lordship has found the time for this hearing. For our part, this has been extremely useful, and it has saved time down the line. So for our part, we're very, very grateful.
We're grateful to the court as well, and just to the court's point, it was we think it was a more substantive hearing than we anticipated, and we're grateful for that.
All right, very good. Well, I shall look forward, if that is the right word, to seeing you on the 12th of March and the 18th and 19th of April, possibly. All right, if you'd like to, if you wouldn't mind both signing, everybody signing out and just leaving me to talk to the court associate, that would be very helpful. Thank you very much.